My name is Herman Edeling. I'm a neurosurgeon and I'm a medical legal examiner and a mediator. I'm here on behalf of SAMLA to welcome everybody and report back in regard to the status of the SAMLA-RAF mediation pilot project. This project is designed specifically for quantum medical mediation, but we think that experience and exposure in this project will be relevant to other forms of mediation as well. We started off offering the RAF a project of 50 matters for free, which would be a research project to analyze the effects, benefits, or problems of mediation across 50 matters, and also to analyze costs, rate of resolution, effectiveness, etc. Since it became known that the project was imminent or that the project had actually started, we've received a very gratifying increase in interest from medical legal practitioners of all professions. And because of this upsurge in interest, we've now agreed with the RAF to increase the scope of the project to 100 matters. We started the pilot project 2 weeks ago on Monday, the 29th of June. And we have now dealt with 6 matters, so we were doing 3 per week. We had a very important business meeting with the RAF yesterday evening, in which we came to certain agreements about how to carry on with the rest of the pilot project. So at that meeting, we agreed to increase to 100 matters. We also agreed that, particularly because of the coronavirus and because of the capacity to mediate effectively by online Zoom platform, there is no longer a need to limit the project to any geographical region. So before the coronavirus struck, it was a Gauteng-based project because the RAF head office is in Gauteng and because many of us are in Gauteng. But now it doesn't matter where you are to participate in this project, whether you're the plaintiff attorney, the plaintiff, an observer or a mediator, or an RAF representative. So we discussed yesterday from the RAF side also branching out and involving their different regional officers in this mediation pilot project. We have done 6 matters so far, all from one attorney, and that is the attorney who, together with myself and Dr. Trevor Frankish, actually initiated the pilot project with the RAF. Of those 6, 1 had to be postponed because there was a very important element of the injuries that had been unfortunately missed by the experts. So because of that reason, the matter was not ripe for mediation. So that 1 matter unfortunately had to be postponed for further investigation. That left 5. 1 of the 5 had to be cancelled because the RAF representative was not able to join the online platform due to technical difficulties. Now, I'm very happy to have been told today that that matter, which wasn't able to be mediated on that day, has subsequently been settled by direct settlement between the parties. And I'm also happy to say that of 20 matters that the original attorney referred to the RAF for inclusion in the mediation pilot project, 3 of those matters have already settled by direct negotiation, prompted by the fact that they were enrolled for the pilot project. So to date, after 6 enrolled matters, 4 matters have already settled by direct negotiation. And as I said, 1 had to be cancelled. The other 4 that we mediated have all settled. So of the 6, we were only able to mediate 4, and every one of those 4 has settled. And I'm also very happy to be able to say that at the end of each mediation, plaintiffs, plaintiff attorneys, and RAF representatives all expressed satisfaction at the outcome and the process of the mediation, which is a very gratifying early result. We have also been able to establish that there have been major savings in terms of time and also major savings in terms of cost in relation to those 4 matters which have been successfully mediated. Now, our formula for the pilot project, which is on the one hand a mediation project, but on the other hand also a professional development project, is as follows. We follow the guidelines and protocol of SAMLA. We start each mediation with a formal pre-mediation meeting at which we make sure that the parties understand exactly what mediation is and that we have properly informed consent to mediate, and at which any questions can be answered, so that we don't have parties or attorneys going blind or half blind into a mediation. And most importantly, in that pre-mediation meeting, we establish what issues are really in dispute and what issues may have become settled, or in many cases, certain parts have already previously been adjudicated. So we establish what issues remain in dispute so that we know what to focus on in the mediation. Each mediation is conducted by a team of 4 people. There is the lead mediator and a co-mediator, and then there are 2 observers. And the process of development, which may be very rapid, but it depends on the experience of individuals, is as follows. When you come into the project as an observer, you observe 2 mediations. In that process, you are actively involved because you have to write and fill in documents, which I will show everybody. So you don't just sit as a dumb observer. You are involved in having to write a report based on what happens. But you do not speak to the parties. However, in breaks and after the mediation, you do speak to the mediators so that we share knowledge and observations. Then there's a mediator and a co-mediator. And our basic model is that one of the 2 mediators must come from the medical side and the other co-mediator must come from the legal side, so that we have a balance of medicine and law. And when I say medicine, I really mean healthcare practitioners, because industrial psychologists, occupational therapists, clinical psychologists, neuropsychologists, physiotherapists, speech therapists, there are many medico-legal practitioners who are not medical practitioners, but who are involved and very experienced in quantification of personal injury claims. So one of the co-mediators is from the healthcare professions and the other one from the legal professions. And they are obviously either attorneys or advocates. And we also have that balance in the observers, so 1 medical observer and 1 legal observer. Then, after that team of 4 has conducted 2 mediations, the team splits up. And the medical mediator will then team up with the legal observer of that team and form their new team. And the legal mediator will team up with the medical observer of that team and form their own team. So that team then splits up into 2 teams. And then a new group of observers is brought in. So we started with 1 team, then we became 2. Now, in fact, the very first time we had 4 observers to enable us to go from 1 team to 3 teams in the beginning. So at the moment, we have 3 mediating teams, and each of those teams as a medical mediator, a legal mediator, a medical observer, and a legal observer. Now, there are still 2 mediations to be done by 2 of those teams before everybody has done their 2 rounds. So after the next 2 mediations, those 3 teams will split up into 6 teams. And then there will be the opportunity to bring in 12 new observers. Those 6 teams will do 2 mediations. And after those 2 mediations, they will split up and they will become 12 teams. And then those 12 teams will bring in 24 new observers. So that is how our process is planned. We believe that it will not work exactly as planned in all cases, because some people may wish to observe more than 2 before progressing to co-mediator, or may wish to co-mediate more than 2 before progressing to mediator. So the progress from observer to co-mediator and from co-mediator to mediator is after 2 exposures, if you are happy and willing to do that. But if you feel that you need more, then we make provision for that. So it is quite a complicated issue to allocate the mediators and observers, especially when everybody is not going to be able to do it in terms of the basic plan. But it is far more important to us that the mediations are done on a high professional standard, and also that there's uniformity among the mediations, so that it becomes an actual test of our guidelines and protocol and our processes of mediation. So far, we've been very pleased with the results. Also in SAMLA, done quite a number, it may be in the region of 30 by now, mediations against provincial departments of health in medical negligence claims. We've done them for Mpumalanga province, for Gauteng province, and 1 in the Eastern Cape. All of those have settled successfully. So we really are very happy in SAMLA for the very happy success and satisfaction ratio of parties that we've been able to assist with mediation. And we are also really pleased for the great interest around the country for people to become involved in these processes and to take forward the practice of mediation. Now, before going any further, I have 2 outside guests in today's meeting. The first is Mr. Hendrik Kotze, Advocate Hendrik Kotze from DISAC, the Dispute Settlement Accreditation Authority of South Africa. And the second is Ms. Sheena Jonker of ADR Network South Africa. Both of them and their organizations have agreed to collaborate with SAMLA in this process, and we welcome their support and their guidance very greatly in these projects. So I would just like now to invite Advocate Hendrik Kotze to make a few remarks, and after that, Ms. Sheena Jonker. Hendrik, are you there?
I'm here, yes. Thank you, Herman, and thank you for bringing together such a wonderful big group of people. It's clear that there's very much interest in the project that you have launched, and that there's a degree of excitement around it that I think is unmatched in the history of mediation in South Africa. So well done for that, and I can assure you that everybody in the industry looks at this project with great hope about what it means for the future in mediation in South Africa. From the ISAC's perspective, I think firstly we just also want to commend SAMLA on the way that it has approached this project in stressing the need for mediators to be properly trained and for mediators to be properly accredited in accordance with the acknowledged standards in South Africa before they are allowed to participate in this process. South Africa does at the moment have a voluntary industry accreditation and qualification standard. It also has a voluntary professional practice standard, which includes a code of conduct and a system whereby anybody can raise complaints if a mediator does not perform to professional standards. However, at the moment, those standards still are based on voluntary participation. I'm happy to say that currently in South Africa, virtually all the major mediation service providers are collaborating with DISAC, have supported this, and participated in the process of formulating the accreditation and practice standards. And so those are widely adopted in the industry. There's also currently a process underway for taking the next step in terms of actually professionalizing the industry and registering a professional body with the South African Qualifications Authority, which will mean that accreditation becomes a matter of regulation, and that in certain cases where people practice as mediator, they would have to have the required standards. So thank you to everyone involved in this project for understanding the need for standards and for making that the bedrock of this particular project. I do get the sense that there are still some quarters and some people who have a sense that anybody who is qualified as a lawyer also knows how to mediate. I'm sure anybody who has trained as a mediator and qualified as a mediator understands the change in mindset and approach that really is required before one can function effectively as a mediator. And for that sense, for that reason, there's a lot of sense in having a minimum standards and for people to train and comply with those standards before they take on the task of mediation. And that certainly seems to be the approach in this project, and so we're very happy about that. I also get the sense from the conversations that I have been a part of that the RAF very much understands that principle and is also keen to ensure that people who mediate in this environment are properly qualified, trained, and understand the subject matter that they work with. So maybe just a final word from my side. Thank you again for this project, and we watch with interest how this progresses.
Thank you very much, Hendrik. Sheena, just before I ask you to speak, I just want to pre-warn the next speaker. I'm very pleased to see Advocate Alan Nelson, SC, in this meeting. Alan, do you confirm that you are still here? Alan, are you here?
I don't see him, Dr. Edling. I think he might have dropped off.
You don't see him?
No.
All right. Ashley, can I just ask you to keep an eye open? Because
Yes.
if Alan Nelson does manage to come back into the meeting, I would just like to welcome him specifically and ask him to make a few remarks.
I'll keep an eye out.
Okay, thank you. Then I'd like to invite Sheena Jonker from ADR Network South Africa to make some remarks.
Thank you very much, Dr. Edling. Good evening to everyone. Thank you very much for having me. So I run ADR Network SA as well as its associated NPO Access to Justice. ADR Network SA does exist as one of the voluntary compliance and regulatory bodies. We've also we've been training ADR and specifically mediators over the last decade or so. All our work is specifically rooted in restorative justice and restorative thinking. I echo Advocate Kotz's sentiments when he says that mediators require high standards of training. as lawyers know that mediation requires oftentimes the unlearning of a lot of adversarial mindsets and ways of doing things. So for us, it's lifelong, ongoing learning. So I also echo his sentiments that standards are required, and as an emerging profession, celebrate the fact that they are taking their dissect through the process of SACWA. So it's been an amazing opportunity to start having dealings with SAMLA over the last while. I had the opportunity to attend a workshop on Saturday, and I was most impressed by the approach to teaching and learning and the way in which the different disciplines are taught the same thing. I think that is a wonderful pioneering effort in this, and I look forward to particularly giving our mediators exposure to work like this within an environment that's supported by the kind of knowledge that SAMLA offers, the resources of the PAC guide, and just figuring out and collaborating to work out best practice in mediation in this particular arena. So Dr. Edling, thank you very, very much for having me. I hope that we will be engaging much more over the next while, and I look forward to seeing how the project unfolds. But I think it's a unique time and a special time for ADR to come to the fore, particularly in regard to the difficulties that this world is facing. We know that ADR methods are flexible, resilient, and exceptionally accessible. So if we do concentrate on developing mediators and adhering to high standards, the potential is unmatched.
Excellent. Thank you very much, Sheena. I want to explain certain things about recruiting participants into this project, after which I'm going to ask Ian Dutton and Michelle Postman to make a few remarks from the Natal Mediation Initiative. And then I'm also very happy to see Dr. Hilde Grobler, who's here, also from KZN. So I'd be pleased, Hilde, if you would be willing to make a few remarks at that point also. And then I'm going to ask the mediators who've been involved in these first 6 to give some of their feedback and what they observed during this process. So what I want to do is to share a screen with everybody to show you what you need to do if you wish to participate in this project. So the screen I'm showing you, I'm going to share the screen now. Ashley, do you see the SAMLA website?
Yes.
All right. So this is the website of South African Medico Legal Association. The URL is medicolegal.org.za. If you look along the top bar, there's a tab called Registered Medical Mediators. If you click on that, you get a drop down, and there you get text which explains what you need to be and what you need to do to become registered on this register. So you can read that text, and then if you go down further, you will see an application form for registration of medical mediators. Now, I must point out that this is not only for RAF, this is mediators who want to participate in RAF personal injury matters, and also those who want to participate in clinical negligence matters against departments of health. So You open the application form, which is there, and fill in the obvious details. You'll then indicate your standing, your professional standing, that you are in good standing with your professional registration authority, and various preferences. And then there are various documents that you need to send to SAMLA. So there in 16A to E are the documents that SAMLA needs to confirm that you are indeed an accredited mediator. And SAMLA will keep those documents on file so that if there is any query from a client at any stage in future, SAMLA has got access to those records. And also, of course, if there is any complaint about professional misconduct, then SAMLA has got access to those records. And then you will sign an authorization, an affirmation, and a pledge. When you sign that, you essentially agree to accept the SAMLA MOI, the Memorandum of Incorporation, to act according to the Professional Code of Conduct and to act in an ethical manner when you mediate. So when you've done that and you submit this registration form together with those supporting documents, then they are checked and then your name goes on the register. Now, the other documents that are here, this SAMLA Guidelines and Protocol to Medical Mediation, that is a document which is now in its 11th iteration. So that's version 11. Now, version 11 has been stable for a long time. And we have used version 11 in mediations now for a long time, and it's stable and it's validated. It's a good guideline and protocol. You will see that the authors of this document are Judge Niels Claassen and myself. We started this document in 2017, and with a lot of consultation from many role players, we've improved it, and it's gone through various iterations until it now stabilized on version 11. Now, this is a general guideline and protocol for medical mediation. So it covers both clinical negligence and personal injury mediation. When we became involved with the RAF to do an RAF project, we developed another document which is a parallel but more specific to RAF matters, and that is Guidelines and Protocol for Mediation of RAF Personal Injury Disputes. So this document, which is now in its 5th version, is an offshoot of the first document. It complies with all of the standards and procedures established in the fundamental document, but it is modified in terms of specific needs and circumstances of RAF matters. And this document, by the way, has now been agreed to by the RAF, and this is an annexure to the Memorandum of Understanding between SAMLA and the RAF. So this document is confirmed by SAMLA and also by the RAF. So when we do RAF mediations, we do it specifically in the terms set out in this version 5 of the RAF personal injury document. It doesn't deviate in any sense from the fundamental document, except that there are specific applications for personal injury. There's also the SAMLA Code of Professional Conduct, and there's the SAMLA MOI, which was amended at the end of last year for purposes of our application to SAQA, the South African Qualifications Authority, for professional body recognition. So these are the documents you need to refer to, and that is how you need to get there. Now, if you click here on this blue link, find a SAMLA registered medical mediator, you will see if you scroll down, you've got 3 pages of mediators, and they are listed alphabetically. And for each mediator, it gives their name, whether they're a registered mediator, and also if they're a registered medical legal practitioner, that will appear. And in that column is the profession, the primary profession of each mediator. So you will see if we go to the last page, there are now at this stage 52 mediators who have registered on this register. So for everybody that has registered, thank you very much for doing that. And for everybody who has not yet, but who does wish to get onto the register and participate in the pilot project, please do that, because we will refer to the names on that register when selecting new people to come in as observers and co-mediators. We are also very grateful for the assistance from Conflict Dynamics. I'm not sure if Marion Sher is in this meeting. Ashley, can you tell me whether Marion is here?
I'll check now. No.
All right. In any case, Marion Sher has been very helpful to SAMLA from 2017 already.
Herman, Felicity Stedman is here.
Felicity is here.
Is Felicity here?
Yeah.
Yes.
Marvelous. Felicity, can
Hello.
you hear me?
Yes, I can. Hello. Very nice
Marvelous.
to see you.
Thank you for being here, Felicity, and welcome.
Thank
I
you.
just want to say that we've been supported by Conflict Dynamics from our initial attempts in 2017 already to get pilot projects going. Felicity will remember that Judge Claassen and I visited you and Marion in Sandton, and we had various discussions. Anyway, we've come, fortunately, some distance since that time. And Marion has recently sent us a list of Conflict Dynamics mediators who were interested in participation, and all of them have now been scheduled in our list of mediators for this pilot project. So Felicity, seeing that you are here, not from SAMLA, but from Conflict Dynamics, would you like to say a few words?
Well, I wanted to just say how wonderful it is to see so many mediators engaged in this project and enthusiastic to get involved and make themselves available. And there are so many familiar names here too of people that we have trained. So it's lovely to see people again. I wanted to really emphasize Hendrik's points and the points you made about professional excellence and quality, because we've always had the view that mediation is only as good as the mediators. And if the mediators do a good job, this is going to gain traction. So I'm really confident that the people who we have here are people who are going to represent mediation well and get us off on a good start. And Herman, congratulations to you and your team. You've done a fantastic job.
Thank you very much, Felicity. I'm now going to introduce everybody to Janae Bakker, who is my practice manager. Janae, can you please say hello?
Hello. I'm frantically typing.
So Janae has been giving administrative and logistic support to the Health Department mediation projects and also to the RAF project. So she files documents, sends out documents, does emails, and Janae is incredibly useful in making these things work. Janae, will you please open up on your screen the document of biographical details that we ask people to provide? So while Janae is calling that up, let me just explain. If we look for, when we come to inclusion of participants in this project, on the SAMLA register, we can see your name and your profession. But in order to work out the sequence of when various people come in, we also want to know how much medico-legal litigation experience you have, and we want to know how much mediation experience you have. So that is why we have created this document, and we will be very pleased if everybody who has not yet done so will fill in this document and send it to Janae. So if you just scroll down there, Janae, you'll see it's just your name, profession, location of practice. Of course, that's less important now that we do everything online. And then an indication of your medico-legal experience, indication of your mediation experience. And if you scroll down, a general indication of your availability and other relevant information. So now, Ashley, Is there a
Yes.
way that they can get that easily accessible to everybody who's in this meeting?
Janae, you can just send it in the chat. You can send a file in the chat, and everyone can download it from the chat.
Okay, will you do that, Janine?
Yep. Can I stop sharing?
Yes, you can stop sharing and then put it in the chat. And then I would also just at this point like to ask everybody who has not yet done so, will you please make sure that in the participants list, your name is correctly indicated with indication of your title, your first name, your surname, and your profession. Because we do need that information to realistically schedule participants into this project. So many people have done so, but I'll be very happy if those who have not yet done so will please do that. So then we will be able to access this list and also those biographical details that you've sent. Now, I'm going to show you now, and I may or may not draw criticism, but I've got to show you. On the basis of information that we've received so far, we've put out requests for information at various stages, we've called various meetings, and various people have indicated interest. We have now started allocating names to the schedule of mediators and observers, and I'd like to just explain the principles that we use in allocation. First of all, we have to have one list of medical mediators and a parallel list of legal mediators. And then we also need to make provision for mediators who have no medical or legal experience. And there are some very experienced and very valuable mediators who know much more than we do about mediation, but who do not have a background in medicine or law. And we also make good use of them in the pilot project. So we have to differentiate between people on those grounds. So there are 3 columns. Then, in order to get the project going, we decided to start off with people who have a lot of experience in medico-legal litigation, so that they would be flexing their muscles and learning to implement mediation, but that they wouldn't struggle with concepts of how to read expert reports, how to analyze expert reports, how to deal with the various legal issues of quantum of damages, etc. As we develop and as this initial group becomes more experienced, we will make place for absolutely everybody who wants to be part of the project. So I'm going to share with you now the screen to show you the allocation we've done so far. And this allocation is done by a committee consisting of myself and Karina van der Waal and Lee de Souza and Marion Scher. So all of us gave input to doing this. Now you will hopefully see your name on this list. If you don't see your name here, please make sure that you fill in the biographical details document that Janae is providing and send it to her. And everyone that we do receive, we will add your name to this list. Ashley, tell me if you can, when you see the spreadsheet.
Yes, I can see it now.
All right, so the way this is compiled, there's the healthcare or expert witness column, there's the mediator column, and there's the attorney advocates column. So the 2 mediators that started off the project were myself and attorney Lee de Souza. And then we had 4 observers, Susan Verhoef, Lance Marais, Charlene Labuschagne, and Trevor Bailey. Now, just to tell you, the suffix CD, that means conflict dynamics. Many other people have been trained by conflict dynamics, but those are the ones that came on the list that Marion provided to me. So if you are a SAMLA member, we haven't indicated where you were trained, but to indicate just this thing that Marion sent us a list and to show that the conflict dynamics mediators have been included in our list. Sorry, Ashley, I see some black marks on my screen. Do you know where they come from?
Dr. Edling, someone's drawing on it. You can just stop the annotations if you go view options and disallow annotations.
Their view.
You might need to, no, not on there, at the very top of your screen sharing, at the very top of your Zoom screen. You might need to stop sharing to be able to do it though.
Okay, let me just do that because this is now interfering with it. Okay, so there it's clean.
So when you share, you'll have an option for annotations. Just turn off allow annotations.
Do I see it at the top? There's an option for annotate.
Yeah, so just turn off allow annotations.
Okay. All right. So, so these 6 people have started, and these 6 have also started. So there are 12 people that have already participated in the first 6 mediations, and Charlene Labuskaghni's group and Lida Souza's group still have to do 1 mediation each for the end of the second round. Then we will be at mediation number 8. Then these people will break up into 6 teams, and each team will take 2 new observers. So here is the list of the next 12 people who will be the 2 observers coming into the next round. So there you will see for these where Marian Sher and Mohammed Raja from Conflict Dynamics are coming in as mediators. They will mediate possibly with a legal or a medical person. But so there are 4 medical people and 6 legal people and 2 mediators in that group. And then when that group has done 2 mediations each, the next 24 are there. Now we have got some names at the bottom which are in the next group, but we expect to fill up that group of 48 as new names come in. Now, whether we get further names or not, I know that we will, with the people that we have here, we will be able to conclude the 100 mediations for the RAF. So we do have enough participants, but we also have room for more if anybody else wants to come in. I'm going to stop that. And then I would like to explain that the purpose of this evening's meeting is to report to the professions what is going on, to explain how our process works, and to invite participation from everybody who's interested. Now, we are interested in participation not only as observers or mediators, but also as legal representatives or as expert witnesses. So if you're an attorney or an advocate and you want to participate in this project by representing your client, we're very happy for that. Because for mediation to be functional, and especially for the large number of matters that may need to be mediated in the country going forward, we need to have mediators, advocates, attorneys, expert witnesses, all proficient in the practice of mediation, how to refer matters and how to represent clients and how to mediate. So there is room for your participation in any of those roles. On this coming Saturday, we have arranged for anybody who's interested to have an orientation and training workshop. So today we are asking people who are interested to join. On Saturday, we are going to talk specifically about how we go about it. So what documents we use, how the procedures work, and certain particular tips and lessons that we've learned in the past few days from this project, and also lessons that we've learned from the health department mediations. Ashley is going to send out details about that project. Now, we have already invited Advocate Michelle Posman to present a training orientation lecture on that occasion. and we've invited Sheena Jonker to present a training orientation lecture at that workshop. And we are going to ask all the mediators who have been involved so far to give their comments, and that will be the opportunity to answer all questions that anybody has about the actual procedures of participation. At this point, I think I've said more than enough. I think it's now time to invite Advocate Ian Dutton to make remarks. Now, let me just say that Ian Dutton is a SAMLA member. He has been a SAMLA director. He has been the chairperson of the KZN branch of SAMLA. And Ian has started a major initiative. I mean, years ago, he wrote a book about medical law. And Ian has now started a website called Prac Guide, a practitioner's guide to medical law and ethics. And in that capacity, Ian has produced some marvelous work in terms of covering the field interface between medicine and law. He's also done some excellent webinars and interviews. And Ian has been a very strong supporter of mediation in general and of SAMLA mediation specifically. So that is why you'll notice that this evening's presentation is hosted jointly by SAMLA and Prac Guide. So Ian, first of all, I really want to extend my heartfelt thanks and gratitude to you for all the support, intellectual and other support, and for the very good work you've done in promoting the ethics of mediation and also just ethical medico-legal practice. Ian?
Herman, thank you very much for that. It really is, it really does motivate one in one's work, and initiatives like this, and we see the turnout we've had this evening, Herman, it's just absolutely phenomenal. And I think I must just, I am going to take a few minutes. There are a few points that I want to make, but I think it really would be only right of me to start by acknowledging the tremendous amount of hard work that you've put in, Herman. And I know how much goes into an initiative like this, not only in the last few months, the last few years, but for decades. And it's been a privilege working with you, and it really is very rewarding to see the kind of turnout that we have this evening. And I will talk in a minute or two, just touch on why it is that I feel that this initiative is so fundamentally important to mediation in this country, to the way that disputes are resolved, and to the broader way in which South Africans deal with each other and deal with hurt and disputes between individuals and between organizations. I must also, I think it's appropriate, Herman, just to say that the attitude of the Road Accident Fund has been absolutely commendable in their involvement and support of this project. I'll take you through exactly why it is that I regard the Road Accident Fund as such a critical role player in the promotion and development of mediation, not only within the personal injury and medical space, but more broadly across the whole country, and touching on every form of mediation. That is obviously with due deference and acknowledgement to all the hard work that's been done by many of the individuals that are present today, and the commitment that they've shown and continue to show. And we've heard a number of people speak about commitments to excellence, commitments to professionalism, and here we see the flowing together of three professions: the legal profession that I'm a proud member of, the healthcare profession, as Herman is, and then many mediators. And Herman has rightly said, those mediators' experience over the last few years and decades are going to be absolutely instrumental in ensuring that mediation is properly conducted within the medical law space. And there are many individuals that know I have contact with them, and that have supported and informed the initiative that we see this evening, and more broadly the initiatives with the MECs for Health. I would just like to take a minute or two to just orientate ourselves, and this project in particular. And I'm going to do that by referring to a High Court judgment that was handed down earlier this year. It was decided, in fact, in March of 2020. And this judgment has an absolutely critical say in what we're doing this evening, and it reflects and locates this project within the context of the legal system and within the context of broader developments within South Africa insofar as mediation is concerned. The judgment it's a judgment of the High Court in the Gauteng division in Pretoria, and it is known as Mabunda's case. It is a matter brought by the previous panel attorneys who used to provide services to the Road Accident Fund, and you will see that the defendant, or the respondent, I beg your pardon, in these proceedings was in fact the Road Accident Fund. What this case was related to was the introduction by the Road Accident Fund of a new model, a new way of resolving disputes that it dealt with and that were brought to the Road Accident Fund. And if we look then, it's a judgment, just incidentally, a judgment by Davis J. And Davis is one of those judges that was trained recently in the States in mediation. So he had an insight and a feel for mediation, and you can see it permeating his judgment. And there's just one or two aspects that I want to highlight for you in regard to this judgment, and it'll help to locate this project in its proper context. Don't worry about the existence of the SLAs. That's just a reference to the various panel attorneys for the Road Accident Fund. But I'd just like to take you to this portion. The High Courts have at various stages and in numerous judgments expressed dissatisfaction and concern at how the litigation model of the RAF, and which particularly in this division, that's the Gauteng division, North Gauteng division, clogs the civil trial role, has been handled over the years. And then there are various references to judgments which have been handed down in which criticism has been made of that particular model. And then at this paragraph in particular, it is not in the interest of justice or proper conduct towards an attorney's client to settle on the date of trial at a huge legal cost to client or public purse. And then there's some details that I'm not going to detain you with at the moment, but I want to take you to subparagraph 24. More than 90% of matters on our trial roll are the Road Accident Fund, or our Road Accident Fund matters, which is funded through the public purse. One would have thought the parties and or legal practitioners in dealing with these matters will be more expedient and professional. However, the contrary appears to be the case. This is despite continuous financial woes the fund finds itself in. And I just want to pause and reflect on that. In other words, what the court is saying here is that more than 90% of civil matters in that division, and I can tell you it applies around the country, are in fact Road Accident Fund cases. And that means that practically all civil cases, or the overwhelming majority of civil cases in these courts, in South African courts, are Road Accident Fund matters. And then the next point that I would just like to take you to is a reference to further judgments, and we really dig down into the figures and the importance of Road Accident Fund matters to not only victims and to the litigation model, but to broader South African society, and how enormous the figures are that we're dealing with. So paragraph 3.4, on average, the value of claims settled by the RAF per month amounts to approximately 4.1 billion rand. The fixed operational expenses for the fund are approximately 800 million rand per month, whereas it receives approximately 3.5 billion rand per month from the fuel levy.
Yeah.
And what's amazing about that is that the monthly shortfall then is quite apparent. The RAF's current unpaid amount due to claimants is approximately 19 billion rand. So we're dealing with enormous figures. Then if I can take you to paragraph 3.19, and that demonstrates the magnitude of the problem that the Road Accident Fund faces and that this country faces. And the old litigation model was simply not working. Those that practice in the courts will know that that is certainly a fact. There are enormous waste of costs, enormous waste of time, and the Road Accident Fund is just sinking slowly into insolvency. And in fact, this judgment, if anyone wants to read it, points out that the Road Accident Fund is at a point where its very existence is now under threat. And there are statutory provisions which could very realistically kick in, which would terminate the existence of the Road Accident Fund and would mean that we would then not have a fund that would pay out victims of accidents, but we would have to seek directly against other parties to the accident. And that means that if somebody seriously injures you, you take your chances as to whether that person has the money to pay you for that injury. So we really are at a point where the Road Accident Fund is starting to face an existential crisis. Now, let's have a look at paragraph 3.19. In order to attain the above-mentioned objectives, there are various, just to take you back one paragraph, I think. The acting CEO of the Road Accident Fund reported that the RAF strategic plan for a 5-year period, 20 to 25, in compliance with the government's medium-term strategic framework, and with due regard to presentations made by the Minister of Transport in a public forum, was presented to the Fund's board at the strategic session held on the 16th and 17th of January 2020. On the 31st of January 2020, the board approved the plan. In the meantime, the chairperson of the board had signed a revised board performance agreement. Therein, 5 priorities requiring attention were identified. These were A, reduction in legal costs, B, revision of the structure and business process, C, integrated claims assessment system, D, rehabilitation network, and E, revision of the supply claim management structure. And then 3.19, the judge goes on to say, in order to attain the above-mentioned objectives, the RAF came to the realization that it must drastically adopt a different model than the previously utilized counterproductive legal strategy. To continue therewith was to increase the RAF's exposure to claimants on a virtually daily basis, whilst at the same time increase its insolvency, all at the expense of the public purse. Should the old litigation model, including the retention of a panel of attorneys, be retained, many, including board members, had warned that the RAF then risked going down the path envisaged in Section 21(2)(a) of the Road Accident Fund Act, which comes into operation when the RAF becomes unable to pay claims against it. The consequence thereof would be dire for claimants, as it would terminate the RAF's position as statutory defendant for claims arising out of the driving of a motor vehicle and would reinstitute the common law position. That's what I referred to a moment or two back. The insured driver, as it is now known, would cease to be insured, leaving claimants with huge claims against impecunious defendants. That's the circumstances where somebody drives into you who doesn't have any money, you suffer a serious injury, and that person is now a defendant, and you just can't get any compensation whatsoever. But then I'd like to just finish by referring to paragraph 3.20. The RAF's new model consists of the intention to settle as many as possible meritorious claims within 120 days. The aim is to achieve a 98% settlement rate. The immediate aim is to target those claims already on the civil roll from the 1st of June 2020 onwards. For this purpose, the RAF intends capacitating itself with an integrated claims assessment system, an additional approximately 255 employees, ranging from legally qualified to whatever other skills may be needed, to enforce the assessment and settlement process, and here we go, to mediate matters where settlement appears difficult to attain. To achieve the last mentioned process, the RAF has already approached the South African Medico Legal Association, SAMLA, whereby medico-legal experts from SAMLA will assist the RAF in settling the majority of its quantum claims. A confirmatory affidavit of a well-known expert, I don't know who this person is, but he's known as Dr. Edeling, and that has also been provided confirming this. In the immediate future, the RAF will be sending teams of staff from its outlying offices to the busiest High Court divisions to cope with the influx of files in respect of matters already set down on the trial rolls. So I would just like to make a few points based on that. Firstly, the enormity of the problem and the gravity of the work that we're involved in. Secondly, the identity of a solution, and most importantly for this evening, the clear identification by the RAF of mediation as a means to address this problem. It is central to their strategy, and I must tell you, at that meeting last night with the RAF's senior legal advisor, he made it quite clear that the RAF was committed to mediation as a way of dealing with claims, and in fact he went a step further and said that this project is not one to assess whether mediation is viable or not as an option. It is not an option. The RAF is going to mediate. What it is doing through this project is just to assess the best way and the best procedures in order to achieve that. Hadman has already pointed to those SAMLA guidelines, which he was instrumental in drafting, him and Judge Claassen, and those guidelines, from when I saw them, I thought these are exceptionally good guidelines, well thought out, and I have seen through the mediations that I've had the privilege to observe, that those guidelines work well. And I'm quite sure that the RAF is gaining confidence in those guidelines, and they are working well for all parties. So I have little doubt that this model of mediation is going to be successful. I can't speak for the Road Accident Fund, and of course we're in early days in this project, but I will be prepared to say that I'd be very surprised if that model or something very close to it is not ultimately adopted by the RAF. So that's the background that I wanted to give you. The work that we're involved in is to promote that model, to ensure that the proper standards are adhered to, and I think we're in exceptionally good hands, both with Dr. Edeling and also with the representatives of the fund that are dealing with this matter. They've contributed in a very constructive and professional manner, and I'm sure that we'll all see that in the weeks and months ahead as this project continues to evolve. Thank you, Herman. Herman, your sound is off.
You're muted, Dr.
Thank you, Ian. Thank you very much for your comments and for that very insightful advocatorial lecture. I have told you how mediators and observers can join the project. I now want to tell you, if you are a plaintiff attorney or an advocate wishing to refer matters to the pilot project, what you must do. So I'm going to put now in the chat function 2 names with email addresses. So you will see there, I've put the name and email address of Mr. Justice Mdluli. Justice Mdluli is the senior legal person at the RAF. He is 1 level below the acting CEO, and he is in charge of this mediation, not only this project, but all mediation on behalf of the RAF. Justice was instrumental in drawing up our MOU and in all the initial discussions and planning, but he has become so busy with litigation, especially against his panel attorneys, that he's had little time to actually run the pilot project. So Justice has more recently appointed Ms. Charnel Dick, who is a manager in the RAF, to actually run the day-to-day aspects of the pilot project from the RAF side. So if you wish to refer one matter or more matters to the mediation pilot project, please send it to both of them. We spoke to them yesterday evening, the meeting Ian is referring to, and they said whatever part of the country they are in the head office, please send your message with your request to them. They will then evaluate the matters and determine which ones can be in the pilot project. And that is not only limited to the pilot project, because one day this will be over and there'll be many hundreds of matters to be mediated on a direct basis or private professional basis. But for the time being, any matters, even whether it's under 41A, that you wish to refer to mediation, those are the people to refer to. I would just like to echo something that Ian said, because it has been absolutely refreshing and very gratifying for me to deal with these 2 people, Justice Mdluli and Charnel Dick. Both of them have demonstrated all the way a completely open, honest, objective, frank and cooperative attitude. And what shines through everything they do, they want matters to come to conclusion. It is really, they are marvelous people, and it's really been a pleasure working with them, because they have made this project able to work, because they bring to the mediations not only a willingness but an intent to settle matters. So I'm very grateful for that. And I'm grateful that where we are cutting our teeth with RAF mediations, that we have the assistance of RAF officials who want to settle. Because if you were to mediate between parties who don't want to settle, that would be where the really tough issues come in and where the failures would come in. I'd like to invite the mediators who have participated so far to say their experiences. So can we start with you, Lee?
Sure, Herman, we can. Obviously echo the sentiments of Ian and yourself. I'm not sure there's a huge amount I can add. But just on a personal level, my experience of the mediations that I've been in thus far is supremely positive. There's been a solid shift in mindset of the fund, like you've both said, and they do appear to be solution orientated at the moment. I think what's also come to the fore is there's so many wonderfully legally qualified minds within the organization itself. And what they seem to be doing as well when it comes to the mediation is they're harnessing on the expertise that they have within their own organization. So it's all positive. You know, the shift from the normal adversarial approach needs to happen. We all know that there are serious problems with access to our courts. So, you know, to have mediation as a dispute resolution tool, it brings dispute resolution right to the desk of attorneys. You know, if one looks in the context of COVID and the challenges that we're facing there, mediation becomes a lifeline. It's hugely easy to facilitate, especially with the fund showing a willingness to, you know, to mediate as well. So I cannot think of a negative thing to say. Individuals at the fund have really, really shown such a positive will to find these alternative solutions. So my only piece of advice, possibly to the profession, is to take the time to take a look at exactly what mediation is. I think from having spoken to some colleagues, there are quite a few misconceptions about what the process is. So yeah, to take a bit of time to look at it and embrace the process. It's going to be amazing.
Thank you very much, Lee. I see the time is stepping on. It's now 23 minutes past 8. I think from my side, I have covered the most important ground, which is to invite everybody who's interested to participate. I've shown you how to participate, what information to provide, and what to send to Janae, and how to refer matters to the project. I will urge everybody who's interested in participating to attend the orientation and training session on Saturday. Ashley from Aslan Creative will circulate information about that. So what that is going to include is, first of all, certain training about the actual administrative or logistical tasks of the mediator, because we're working in a pilot project and there are certain procedures that have to be performed correctly because of the research project. Secondly, how to use the Zoom for online communication, how to invite people, etc. But more importantly, from the lessons we've learned and from the experience of some very experienced mediators, some tips and tricks about how to go about the process of mediation. So I urge everybody to please attend that training and orientation session this coming Saturday. What I would like to suggest now is, instead of inviting people to speak, I want to invite anybody who wishes to comment or ask a question. Will you please type your name in the chat function, and then depending on who's first, second, third, I'm going to ask Ashley to monitor that chat function and indicate who the next person is that has a question or a comment. When your name is called, if you will please just unmute your microphone so we can hear you. And if your camera is off, we'd be pleased if you switch your camera on so that we can also see you. So is there anybody who wishes to ask a question? Ashley, I see there Oscar Shimanga is asking what time is the meeting on Saturday? Ashley?
So yeah, we said that would be 11 o'clock on Saturday.
That's right, 11 o'clock. Yes.
Okay, and then we've got a question. Will the info on the training and orientation session be posted on the SAMLA website? I'm sure we can speak to Karen. I think Karen's on here.
Yes, Karen, are you here? Karen Levine?
I think she was. She might have been load shared. No, she's here. Hold on. Let me ask her to unmute. Karen, can you hear us? Karen?
Karen is now unmuted, but still not visible.
Okay. No, I don't think she's actually
Okay,
there.
well, anyway, I will definitely ask Karen to put that information on the SAMLA website. And Ian, will you put it on the Prac Guide website?
Yeah, I will, Herman.
Thank you. And then Ashley, will you please circulate that information to all the people on the SAMLA mediation interest group that we have on the forum?
I will do, and it will be online training as well.
Yes.
Okay, then we've got another question. What is the expected timeline in terms of your list? That's Advocate Catherine Reed.
Okay, I'd actually prefer people to ask the questions themselves.
Okay.
So,
Yes, hello.
Can you,
Yeah.
hello.
Hello, Herman. The list that you put up, the Excel spreadsheet, what are the expected timelines for that?
All right, I'm going to go to the list and I'm going to explain it to you. Okay, so can you see the list here?
Yes, I can see it. Thank you.
All right. So these first three groups were to do 8 mediations. 6 have been done. Because of a lot of technical and connectivity difficulties that we in the RAF experienced, they've asked for a 2-week break to sort out all of their laptop problems and IT access problems and IT blockage, whatever. So we're commencing again on the 27th of July. So, and from then on, we are going to be doing 3 mediations a week. They said that's the most that they can cope with from their logistics. So mediations number 1 and 2 have happened, and then of the next tranche of 6, 4 have happened. So 2 still. So in that week of the 27th, the Monday and the Wednesday will be mediation number 7 and 8. So then after that Wednesday, at the end of July, we'll split up into 6 teams, and then these 12 new observers will come in, and then those 6 teams will each mediate 2 matters. But so 6 times 2 is 12 mediations at 3 a week will take 4 weeks.
Thank
so
you.
It's 2 weeks before we start. This group will be 4 weeks. When that is completed, then we'll break up into 12 teams, and 12 teams will do 2 each. That's 24 at 3, so that will take 8 weeks.
Thank you. I understand. Thank you, Herman.
Okay, next up, we've got Gugu, who's got a question.
Let me see after this.
We can hear you.
Okay. I just wanted to find out during registration, do you have to email the whole MOI or just the signature page?
I'm sorry, Gugu, I don't understand.
When you're doing the registration,
To get onto the register of medical mediators.
do you have to email the whole thing or just the signature page?
No. Let me show you. You have to send everything, Gugu. You have to send. I'm going to show it to you here. I'm sharing screen again. So what I'm showing you now is on the SAMLA website. This is the medical mediators page. So if you go there to that application form,
Yes.
you have to fill in the whole application form, which you sign, and then you have to send that together with all of these documents in paragraph 16A to E. So all of those documents have to be sent together with your form. They go to the SAMLA secretary, who is Christa Kulevane. The address that you send it to is on the form. You see that info@samla.org.za. So Christa receives and checks the documents, and she files them in SAMLA's central filing system. And if the documents comply, then she will register you on the medical mediators register. And if there's any uncertainty or question, then Christa consults one of the SAMLA Exco members.
Thank you.
Any further questions or comments?
So we've got another question from Bafana.
Yes, Bafana. Please unmute your microphone.
Can you hear me?
Yes, I hear you now.
Thanks a million. I just wanted to double check whether the invitation could be extended to court mediators which were appointed by the minister last year in terms of their experience.
Okay. Now, Bafana, I'm not exactly sure how that system worked. And I'm not sure what similarities there are or may not be between that mediation process. Are you talking about the magistrates court, the court annexed mediations?
Court annexed mediators.
Okay. So what we have now from SAMLA is that you must be an accredited mediator. And we are not a mediation accrediting authority. So we accept the accreditation of DISAC and CEDR and ADR networks. If you are accredited with one of those three organizations, then we accept that you are a suitably accredited mediator. If you have been mediating in a different way or with another organization, then you would need to get accreditation with one of those three. So those are the organizations who assure SAMLA that people with that accreditation have been properly trained in the skills of facilitative mediation, because that is the essence of what we do. Our whole medical mediation process is based on facilitative mediation. So if you're not sure about that, perhaps you can talk to Hendrik Kotze from DISAC. Hendrik, are you still here?
Herman, I think he said that he had to drop off. I think I saw a message from him.
So, yeah.
Right. Let me then just ask, because I don't know the real answer to that question, but let me first ask you, Bafana, do you have accreditation from DISAC or CDEDR or ADR networks?
No. Let me give you an example. We were appointed by the minister last year.
Yes.
As mediators from Department of Justice. So I just wanted to double check whether one could be allowed to apply so that could form part of mediation. But if you say you need to have an accreditation from the institutions that they have already mentioned, one will try to look at everything.
Yes. So unfortunately, because SAMLA is not a mediation authority, and we are not in a mediation training or accreditation body, we are dependent on those bodies that we know accredit facilitative mediators. So if it is so that those persons who were appointed by the minister are trained adequately in mediation according to the standards of DISAC, for example, then they can apply to DISAC to accredit them. And then with a DISAC accreditation certificate, SAMLA would know that we are able to accept that. If DISAC, for example, or ADR networks were to say, no, there's some differences or whatever, you need to undergo some further training or orientation, then we would be dependent on their decision in that regard, because they are the authorities for mediation accreditation. Is Sheena Jonker still here?
No, Sheena had network issues. She's had to drop off.
Yeah. That's
There's
right.
another question.
Load shedding at 8. Is there anybody here? Hilda, do you maybe know?
Yes. And
Gresham,
Herman.
yeah.
Oh,
Yes.
I see Gresham is here. Gresham, yes?
Yes. Thank you for that, Herman. Thank you also for the great info for the evening. I wanted to just apologize on behalf of Sheena firstly to say that they've had load shedding, so she had to actually get off.
Yes.
And so I'm just filling in on behalf of her there. And just to, there's lots of people that are, concerned about the mediation and accreditation and training.
Yes.
And of course, the orientation that's happening on Saturday. So
Yeah.
I think it's vital that everyone, just to get onto the same page, that they at least attend the orientation on Saturday, so that everyone, we're singing off the same hymn sheet. And then also training that's happening is commencing on Monday. There's a 5-day mediation training. The training that is usually accredited has to be at least a 40-hour training session. So it's usually 5 days of 8 hours. And so that would be from Monday to Friday next week, has been specially arranged for this particular project. So the focus is going to be on personal injury and medical malpractice, etc. So, and RAF. So it's, if anyone needs to get onto that training, it would be, I would put up on the chat, Carrie Morgan's detail, and they can just contact her directly, so that all the mediators that need to be trained, they could be trained, at the same time. And that will be held via Zoom. So it'll be an online training as we're having it now.
Thank you very much, Christian. Let me just point this out. I see some questions and comments in the chat function, MIM and conflict dynamics. Look, I was trained in mediation at MIM, and I was accredited by DISAC. My wife and son were trained at conflict dynamics, and they were accredited by DISAC and CEDR. So MIM and conflict dynamics are mediation training organizations, and DISAC, CEDR, and ADR Network are accreditation authorities. So let me just ask, Hilda, are you able to shed light on the status of court annexed mediators in terms of being accredited mediators for this purpose?
Unfortunately not. It was one of those programs that we did, and it was to be rolled out nationally. I believe it was rolled out in Gauteng. It hasn't happened in KZN. And
Yes.
I'm not sure what the status is or where any of us will end up who did that particular course.
Thank you. Is Felicity Stedman still here? Felicity?
No, she's greeted and left the meeting.
She's left. Michelle, do you know?
I don't. Sorry, Herman.
Okay, so unfortunately then, all I can say is that for anybody who does not have a certificate from DISAC or CEDR or ADR networks, which are the 3 certificates that SAMLA is authorized to accept, please contact any one of those organizations, and that also includes conflict dynamics or mediation in motion or ADR networks, to either get training if necessary, or to get accreditation if you already have adequate training experience. But we are dependent on those authorities to certify to SAMLA that you are an accredited mediator. Ashley, are there further questions?
We've got another question from Gugu.
Yes, Gugu.
Sorry, it was the same question about mediation in motion, because our understanding was that after finishing the training, we were accredited.
Yes. So if you were trained by mediation in motion, like I was, you'll have accreditation certificate from DISAC.
So we still have to contact DISAC.
No, if you've got a certificate from DISAC, then that's what we need to put you on the SAMLA register. We
only got a certificate. Oh, sorry. We only got a certificate from MIM.
Okay, then you must please contact MIM and ask them for your DISAC certificate or how to go about obtaining it. Because MIM is accredited by DISAC to give training. and people who are properly trained by MIM get accredited by DISAC. So if you don't have it, contact MIM in order to get it.
Thank you.
Sorry, I see Karen Levine is now here. Are you speakable, Karen? Karen, can you unmute yourself?
I'm unmuted now. Can you hear me?
Okay, so Karen, the particular question to you is,
yes,
if Ashley sends you the information about Saturday's orientation and training session, will you put it on the SAMLA website?
I will indeed.
All right. Thank you. Ashley, are there any further questions?
I think they've all been addressed now. I'm just going through them. They all seem to be about accreditation. I see Michelle has posted in the chat the organizations that are DISAC accredited.
Okay, thank you very much,
Which
Michelle.
helps a lot. Thank you, Michelle.
Conflict Dynamics, Equilaw, the Mediation Company, Royal Institute of Chartered Surveyors, Tokiso, Mediation in Motion, Africa Dispute Resolution, Mediation Forum, Justice College of the Department of Justice. Okay, thank you, Michelle. So if there's anybody else who wants to make a comment or question that we haven't dealt with, can you please raise your blue hand? Ashley, can you just explain to people how to put up their hand so that we can see?
So if you just click on participants, and there should be 3 dots, and you can just raise your hand. That doesn't look like it. Otherwise, if you can't do that and you can't figure out how, just send a message in the chat, say that you still have a question.
As you hover over your name, and then there's an option to raise your hand.
If you click on participants, there's 3 dots at the bottom, and then you can raise your hand.
I see at the bottom of the list there's 3 dots.
Yes.
Okay. Thank you.
It's a little blue thumb in
Yes.
case.
I think we're good. There we go. Advocate Makamu.
Yes, Advocate. Advocate Makamu. I met Advocate Makamu 2 weeks ago in one of the mediations. So it will be nice to hear from you. Will you unmute yourself, please, so that we can take your question? Advocate Makamu, can you unmute yourself?
Yes. Yes, I've unmuted myself, but unfortunately, I just raised my hand by mistake. I don't have it.
Am I correct, Advocate, that you were present on behalf of the plaintiff in one of the mediations we did these past 2 weeks?
Yes.
Okay, well, welcome. Nice to hear you here. Can you just tell us, Advocate, you were representing a plaintiff in that matter?
Yes.
Were you satisfied with the outcome of the mediation?
Yes, we were very satisfied with the outcome of mediation.
Yeah.
And even the client was satisfied.
Okay, thank you very much, Advocate. I see Michelle Postman has raised her hand. Michelle, please unmute yourself.
Thanks, Herman. I just wanted to clarify on the accreditation. So how DISAC works is it devolves its accreditation to the service providers. So those particular service providers are DISAC accredited, which means anyone who is trained through one of those organizations automatically is DISAC accredited. So anyone who has been trained by any one of those organizations will easily be able to get DISAC accreditation or a certificate indicating that they are accredited.
Okay, thank you very much, Michelle. Rowan Harhoff has raised his hand.
Yeah, Herman, I was just wondering if you could give a little bit of details to how experts are brought into mediation and utilized in mediation.
Yes.
In other words, they're not mediators themselves, but they're required for some sort of evidentiary input or...
Certainly. So, Rowan, that also reminds me there's another aspect I must address, because we've only been talking about the RAF project here, but we do also have a clinical negligence project going with the Gauteng Department of Health, and there's a very good chance with the involvement of Michelle and Ian and Sheena now that we're going to start a similar project in KZN. Now, there is a very important role for expert witnesses in mediation. If we could have our way and matters are referred to mediation at an early stage, we would advise the parties to appoint single independent experts as joint appointments instead of two opposing experts who feel they've got to fight with each other. We have already done that process in a number of the clinical negligence mediations, and that has worked well. Now, for example, in the Gauteng and in the Mpumalanga project, we would come, Judge Claassen and myself, to a pre-mediation meeting. We would determine that we need an occupational therapy report and an actuarial report, which is not available. Then we would advise the parties to appoint an occupational therapist and an actuary, and then when their reports are in, we would come back to the mediation. Now, many of those claimants, especially in the clinical negligence matters, are impecunious, and many of them don't have legal representation because they can't afford it or they don't know how to find it. So when we come across people who need experts and who need lawyers, we call on SAMLA members who are experts or lawyers to provide their services also free of charge, like the mediators, to either give expert evidence or to represent clients. So any expert witness who's willing to do that, we would be very thankful, and that will apply to matters which come to mediation at an early stage and where there are not yet sufficient expert reports. However, at this point in the RAF project, all the matters that they are referring to mediation now are trial ready. So all of them come with court bundles already prepared, and they already have two teams of experts in these. So for those trial ready matters, we don't need any additional experts, and we also don't need lawyers because they are all represented. Mr. Justice and Bluley did tell me that they are interested, the RAF, also in testing the application of mediation at earlier stages, so that they want to refer some earlier matters to mediation. So if we get in the pilot project matters at an early stage that still require expert input, then we would want to ask SAMLA members who are experts to participate. So I want to invite you, apart from joining the Medical Mediators Register, if you are willing to offer your services for the purpose of the pilot project, either clinical negligence or RAF, free of charge, in the capacity as an expert witness, please send your name to Janae so she can maintain a list of people that we can ask under those circumstances.
Herman, I haven't heard you saying anything about interpretation and translators.
No, thank you very much, Judge. We have had, obviously, certain mediations where the claimant does not have English as their first language, and it's very important that they must understand exactly what's going on. So in all such cases, we've had to make use of the service of translators. We know that traditionally in court, one makes use of court-appointed interpreters. We have found in mediation that we prefer to request the interpreter, if he is so called, not to interpret what he or she thinks the claimant means, but to translate directly for us our words into the mother language of that person and the words of that person directly into English, so that we can be sure what the person has understood. So we are quite particular in that we ask translators in mediations to act as translators, direct translators rather than interpreters. And of course, any claimant, plaintiff attorneys who refer matters to the pilot project, whose clients are not English speaking, will need to bring their client with a suitable translator. In terms of the capacity to communicate over the Zoom platform, if the plaintiff has their own computer and their own internet access, then the attorney can arrange that. In other cases, the attorney has physically brought the plaintiff to the office of the attorney, and they've participated on Zoom from the attorney's office. But it is a responsibility of the plaintiff attorney to make sure that the plaintiff, him or herself, is able to communicate adequately, and when necessary that there's a translator. Thank you very much, Judge. Leader Souza, you had your hand up?
Hi, Herman. Yeah, I did. We've shifted off the topic a bit, but just in relation to court annexed mediation, LEAD, which is the educational division of the Law Society of South Africa, I know did hold or advertised that it was going to hold some mediation training, and I think that was aimed at court annexed mediators. And I did a quick search just to get some information there, and they did actually publish accreditation standards for mediators in court annexed mediation. It does incorporate the 40-hour required course. So I guess the question would be, in those circumstances, whether they registered with DISAC and whether DISAC recognized that training as a qualifying institution.
I think that is very important, Lee, because DISAC is an accreditation authority, and it's not for SAMLA to decide who's a mediator. It's for a mediation accreditation authority to make the determination.
Correct, yeah.
Further questions or comments?
I think how long do we anticipate the orientation to be on Saturday? That's been brought up.
I had an idea it would be about 3 hours, Ashley.
Perfect.
I see Dr. Trevor Frankish is here. Trevor Frankish is the chairperson of the SAMLA Mediation Committee. He was instrumental, together with me, in getting this RAF project going, but then he withdrew and left it in my hands. But Trevor is still running the Gauteng Clinical Negligence Mediation Pilot Project. Trevor, do you wish to make any comments about the clinical negligence project?
Thanks very much, Herman. I won't go into a lot of detail, I think, just given the time. Possibly we can share some of the learnings on Saturday as well. I think, yeah, there were quite a few things when we did the first couple, well, not really the first, but as we got rolling with the Gauteng MEC's office in terms of the logistics. It's also been, I think, all of the cases have been successfully settled as well. And then if it's okay with you, maybe we can share the learnings on Saturday, just given the time.
Excellent. Okay, that would be great. I've just realized something, and I'm really sorry that I didn't think of this earlier. We are trying to align the RAF project and the clinical negligence projects to run on the same organizational model. As you see, we've got this spreadsheet that I've shown you with allocation of people from observers and mediators. We are now compiling a parallel spreadsheet for people involved in the clinical negligence trial. We do want to know from you whether you want to participate in the RAF trial or in the clinical negligence trial, or both. So there are some people who have participated in both, but if you wish to participate in both, we want you to indicate your preference. So in other words, if your preference is to do the clinical negligence trial, but you also want some exposure to the RAF trial, we'll put you higher up on the list on the negligence trial and lower down on the RAF trial. If you are mainly interested in RAF, but you'd like some exposure to the clinical negligence, you'll go higher up on the RAF list. If you're only interested in RAF or clinical negligence, you'll only be on one of those lists. So what I wish to ask you then, before we terminate this meeting, just to help Janae and our committee and Trevor's committee in allocating observers and mediators, would you please, in the chat function, just write your name and say only RAF project or only clinical negligence projects, or if it's both, what is your number one preference and which is your number two preference? So please, if you will do that before you leave the meeting. And as I said, we will be recruiting participants not only for the current Gauteng trial, but we are anticipating imminently a similar trial in KZN. And if Dr. Laram is at all successful with his communications in the Eastern Cape, we may also be able to run a similar trial in the Eastern Cape. And also, let me say at this point, for people from any other province in South Africa, if there's enough interest from the state, the Provincial Department of Health in any other province, we will be willing from SAMLA side to organize a mediation pilot project in any one of the provinces. And it has become a lot easier to do that now that we are able to mediate online, because it means we don't have to fly mediators around the country to go to different towns. So at this stage, if you would just please use the chat function to indicate your name and which project you are most interested in, or if you are only interested in one, so we can organize those lists in a rational sequence. All right, I think that is all I needed to say. I hope I see everybody at the training. The training and orientation will be provided by other people. I will only make a few comments, and we're going to be heavily dependent on experienced mediators and also my colleagues who've assisted with the mediation so far in terms of that orientation.
I see we've got a raised hand, Mr. Dirk Pretorius.
Hi, thank you so much. Dr. Edeling, I'm an industrial psychologist. I would just like to ask you quickly, in terms of the training, if one obviously needs a practical component, after the training has been done. So I'm considering doing it next week. So can one contact anyone later for some exposure if we can't immediately participate in the current process for the medical or the RAF? Is it possible to join later in being an observer or a co-mediator?
Yes, let me try and answer that. We have set up these pilot projects, but one day the pilot projects will be finished and people will be paying for mediations.
Yes.
When the RAF and departments of health or premier's offices or insurance companies start asking for mediators, our recommendation, our request to them will be to allow observers also to sit in for the purpose of exposure to more people for mediation. During the pilot projects, the presence of observers is part and parcel of doing the project free. So that is why we do it free, to allow observers. Depending on the goodwill of clients, later on, we hope that they will see the benefits to the society of allowing ongoing participation by observers. So if you become trained and accredited as a mediator at any stage in future, please get your name on the SAMLA Medical Mediators Register.
Yes.
Because if anybody were to ask me or Ian Dutton or Lee D'Souza or Michelle Postman to mediate a matter, we will ask whether they will allow observers, and we will look on that register for people who wish to observe, who have not had the opportunity to invite them to observe.
Wonderful. Thank you so much.
Thank you. Ashley, are there further questions?
No, there don't seem to be.
Okay, so then with that, I thank everybody for being here, and we close the meeting. I'm going to ask Ashley not to stop it, so that everybody has the opportunity just to write their name and their preference in terms of participation. So please, before you leave the meeting yourself, just write your name and your preference.
Dr. Edler.
I see there, for example, Dr. Mpotwana, you said you want to, you are equal in both, but please just choose one as your preference, because I don't know how to allocate you if it's equal?
I don't have a box for both,
No?
unfortunately.
If you just write next to your name, if you just write which one is your preference, because you will be allocated to both, but we would like to know in what sequence to allocate you. Well, with that, I thank you. The meeting is over, and I hope to see everybody on Saturday. Thank you very much.
Thank you, Herman. All the best. Have a good evening.
Thank
Bye-bye,
you.
everyone.
Bye.
Thank you, Herman. I thoroughly enjoyed it.
Pleasure, Ethelwyn. Thank you.
And I'll join you on Saturday too.
Thank you,
Get my
Ethelwyn.
training soon.
Thanks, Herman. Good night.
Thanks. Good night.
Good night.
Thanks, everyone. Good night.
Thank you, everyone.
Bye. Thank you very
Goodbye.
much.
Thank you for everything.
Thank you, everyone. Good night.
Good night.
Name.
Yes, I'm
Are you
here.
going to download the chat?
I have to because I'm getting an immense amount of private messages with the answers. So I'm like, please do not exit me from this meeting
No, we
until.
won't. You're a co-host, so you shouldn't have a problem. Let us know if you've got a problem, though, okay?
Do not eject me. Thank
I
you.
won't eject you. I will save the chat too, but obviously I won't get your private
The
messages.
private messages, and I don't seem to be able to. I just want to check something.
You should be able to save the chat.
Privates. That sounds wrong. Sorry.
Save the whole chat. If you save the chat, it should save your private messages.
Yeah, that's what I'm checking now. Oh, yes. Yes, it does. Wow, it looks amazing in text format.
Ashley, how do you save the chat only?
So if you click on, so if you open the chat, you should see 3 little dots next to file. You might not be able to because I don't think I've allowed participants to save, but hold on 1 second. Let me.
Okay, it's just for future reference.
No, that's
For when
fine.
we-
Let me
yeah.
just give me 1 second. I'm just going to change a setting and then you'll be able to.
So, Ashley, are you going to promote Trevor to co-host and he can save it?
I am.
Good. Yeah,
I
because
think
I think
that'll
it's
be quite
important, Trevor,
useful.
for you to have that information so
Yes.
that you can allocate
Yes.
properly in the clinical negligence projects.
Would we be invited for Saturday? How do we join Saturday?
Ashley is going to send an invitation to everybody in the SAMLA mediation interest group, which is 130 or so people. She's also going to send an invitation to everybody on Ian Dutton's prac guide group and also to ADR networks she will distribute to all their mediators. Is that right, Ashley, or are there any other
Yes.
groups? And we're going to put it on the SAMLA website and on the prac guide website. So if you're on any...
What about the people that attend? Sorry, what about the people that attended today? Will you also send an invite to us as well?
If you were logged into Zoom and entered your email address when you entered the meeting, then I'll be able to. If not, you can just check for the details on the SAMLA website, which is medicolegal.org.za. I'll put it in the chat now, and just watch the website tomorrow for those details.
100%. If I put my email on the chat and ask to be put on for Saturday, would that be fine?
Send it to me privately on the chat, to Ashley Aslan in the chat, and then I'll make sure that you get the invite.
Sorry, Ashley, if I can just check now that I'm made co-host.
You should be able to. So if you open the chat and
yes,
you'll
I've got the
see
chat.
everyone, and then you see file, and then there's 3 little dots.
I can see 3 little dots.
Click on the 3 little dots, and you should have an option to save chat.
And I don't have that. I have thumbs up, I have clapping hands, I have coffee.
No, you're under
that's not the
participants now. You got to look at the bottom of the chat.
Ah, okay, at the bottom of the chat. Oh, I see. Okay. Oh, right.
It is a bit confusing.
Perfect. Okay, thank you very much. I've got that now.
Trevor, the actual thing is you have to be a millennial to understand this.
I've learned.
Or an octopus.
Yeah. I'll have to have a grandson or someone to come and sit with me for this.
Yes.
Okay, thanks very much. I've got it. Yeah. Okay, thanks a lot.
Thank you.
Bye.
Bye-bye, Trevor.
Bye-bye, Trevor.
See you on Saturday.
Bye, Trevor.
Ian?
Yes.
You are going to get yourself ready to do some orientation and training on Saturday.
I saw that one coming. No, with pleasure. That's fine.
Yeah.
Particularly, I think on the Adman, I think what is I don't know what you've got in mind, but what occurs to me is just to give some feedback, really, on the from the heart of the matter on the experiences of watching the mediations, and and how it works and what has happened and what the impressions are and what have you. I think that'll be useful for people to know.
So, Ian, the areas that we need to cover in Saturday's orientation and training, the one is the practical, administrative, and document-related issues that you've now had exposure to, so that everybody knows what documents to fill in and what they need to do on a practical administrative level during the mediations. The other thing is just to tell them that everybody has to have access to Zoom, that the mediations are done on Zoom, and that by the time everybody becomes a lead mediator, they must have their own Zoom Pro account, because the lead mediator will have to run the meeting. And then I will talk about the particular responsibilities of the lead mediator, particular responsibilities of the co-mediator, and particular responsibilities of the observers, because each one has got a particular job to do over and above running the mediation.
Yeah.
In terms of the pilot project, data acquisition, etc. And then, Ian, we want some insight in terms of how to mediate, especially seeing that this is now a specialist type of medical mediation, which is RAF personal injury matters, where we are largely talking about professionals' expert opinions where there's differences, and we're talking about money and contingencies and provision of trusts, etc. So those legal concepts, how we actually deal with those things. So the thrust or the context of this mediation is different from family mediation. It's different from labor mediation. And it's different from clinical negligence mediation. It is RAF litigation done in a mediation format. So what are the particular tricks of the trade? How does the mediator actually help the parties to get to agreement? You and I have had a number of discussions about this over the last 2 weeks. So any advice that the people who've been involved so far can give their colleagues about what we've learned helps and what doesn't help.
Herman, how long do you think that you want me to I don't want to, how long do you want me to talk on those subjects for?
Okay, I'm going to ask Hendrik Kotze to talk. And Sheena,
Can I just make a recommendation to you quickly, guys? If you suspect that the orientation and training on Saturday is going to last for 3 hours, you've got to plan a break.
Yes.
People can't. A 2-hour Zoom session is a lot. A 3-hour, I don't think is possible for most people.
All right. Okay, so let's bear that in mind. But Ian, Hendrik will talk, Sheena will talk, you will talk, Lee, Michelle, Charlene, and me. I want all of us to talk, to share our experiences and give our advice. And I also want Ashley to talk. Now, Ashley will talk a little bit about Zoom, but Ashley is not going to reproduce her one-on-one training in Zoom, which is a separate program that Ashley offers, which some people have done and derive great benefit from. Ashley's just going to give some pointers about how to use Zoom or how to get a Zoom Pro license, etc. So if you divide that up into 3 hours, it's 5, 6, 7, 8. That's less than half an hour each. So I think everybody must talk for 20 minutes.
I think it's about right. Yeah.
And then we will need to field questions.
Sorry, Dr. Edling, just a quick one. Linda Nordia is still on. She says she's been trained by Mediation in Motion with a certificate issued by UCT. Is that validated by DISAC?
Yes, Linda. Mediation in Motion's program, which I also did, is done in collaboration with UCT Law at Work. But the actual accreditation comes from DISAC because DISAC accredits Mediation in Motion. So yes, that is correct.
Good. Thank you very much. So I don't need to apply for a different certificate. I can just fill the forms.
If you have a certificate from UCT MIM, that means you are DISAC accredited.
Good. And just, I did also write on the previous little box, I did the training. I actually also helped them once with training as a facilitator, but I don't have any experience. But that I suppose would come in my bio and you would allocate one according to that.
Exactly. Yes.
Good. All right.
What is your profession, Linda?
I did many years. I've retired at the end of last year, and I'm a medical doctor by training. But I did about 20 years of doing the hospital administration, being a medical, like a CEO for a district hospital in Cape Town. So I dealt with many medical legal complaints. Yes, that's an old-fashioned superintendent.
Yeah.
Yes, absolutely.
Okay, thank you, Linda.
Thank you very much. I'll leave now. It's really interesting, and I've asked that they invite me for Saturday.
Great. Thank you, Linda.
Good. Thank you. Bye.
Thank you.